Good afternoon, everyone. Welcome to today's webinar on developments in education law and the impact on private schooling. My name is Tim Fletcher. I'm a director in the Dispute Resolution Department of Cliff Decker Hofmeyr and also presently chairperson of CDH. We are delighted to have you join us as we explore the significant changes and emerging trends in education law and how these developments are shaping the landscape of private schooling. It's a privilege also to introduce our first and keynote speaker for this session, Dr. Farinaz Veriava. Dr. Veriava is a renowned public interest lawyer and academic, currently based at the University of Pretoria, where she teaches education law and the law of delict. She has a Doctor of Laws from the same university, and appropriately, her doctoral thesis is entitled The Contribution of the Courts and of Civil Society to the Development of a Transformative Constitutionalist Narrative for the Right to Basic Education. She is also a Senior Associate to the UNESCO Chair on Education Law in Africa. And before becoming a full-time academic, Dr. Veriava was the head of the education program at the public interest organization you'll know as Section 27. At Section 27, she built and led several of the groundbreaking cases in respect to the right to basic education. Practice and advocate. She's worked at the Centre for Applied Legal Studies at WITS, at the South African Human Rights Commission, and at IDASA. She's published in academic journals, books, and in popular publications on the right to basic education, public interest litigation, and on socioeconomic rights more generally. She's also edited 2 editions of the Basic Education Handbook, which is a widely used resource on education rights. From that very impressive resume, you will agree with me that Dr. Veriava is well qualified to talk to our topic today. And it is my privilege then to hand over to Dr. Farinaz Veriava.
Thank you very much, Tim. I think probably what qualifies me even more than my legal and academic work, which has focused mainly on under-resourced schools, is the fact that I have 2 sons who have attended some of the most well-known private schools in Johannesburg. And so I am, even though I never went to any of these very privileged schools myself when I was a student, I do have some insights into the institutional culture at these schools. I should say that while my boys went to the very good schools, as I said, there is a range of private schools now in South Africa, starting with the low-fee schools to the middle-of-the-range schools to what is known as the elite schools. But to move on to my discussion for today, I have been asked by Tim and others to speak on the Basic Education Laws Amendment Act, which has just recently been signed by President Cyril Ramaphosa to much controversy. And I will be speaking to that. There will obviously be some parallels between some of the changes there and what people in private education would be thinking about. And also one of the things that's been raised with me when I was asked to speak was what happens next? Is there going to be a similar regulation of private schooling? I obviously don't have a definitive answer or an inside track on this, but I do have an opinion on what schools could be doing to make themselves more ready for any changes that may or may not emerge following the passing of the Bella Act. Next slide, please. So to just highlight some of the purposes that have been stated by the previous Minister of Basic Education, Minister Motshekga, is that obviously this act has been the SASSA, the South African Schools Act, and the Employment of Educators Act have been in force since around 1996. And from time to time, it is important to be aware of changes in the basic education policy framework, and to update the legislative framework to take note of the broader changes, socio-political changes, socio-economic changes, jurisprudential changes, and so forth. A lot of Bella, as stated by the minister, and as those of us that have studied it will be aware, that many of the changes have been driven by the immense litigation that has happened over the last 26 years, particularly in school governance, but not only in school governance. Over the years, there also, as would happen, law and policy gaps would emerge, systemic issues will emerge. One such systemic issue that I will touch on briefly, things like dropout learners or retention of learners, which came to the fore during the COVID-19 period. The last big change happened in 2005, as people may well be aware, which was when we had a lot of the changes to the school funding framework, which introduced no free schooling. So that is, in a nutshell, the purpose of the Bella Act. And if we can move on to the next slide, please. So this looks like a lot in terms of my overview. I will go through it quickly. Some of it I will say more about than other sections. Obviously, the two most controversial sections would be the changes to the admission and language policy making functions of SGBs. What was also controversial was some of the regulations around homeschooling, but I think the homeschooling sector has made their peace with that. I will start by talking a little bit to the timeline, because I want to make clear to people how politically contested this process was, and through that also perhaps highlight how people can engage the public participation process in their own interests. We will talk a little bit about the definition of basic education, where there is finally a lot of certainty, and included in that is the introduction of a compulsory grade R. We will talk about the enforcement of compulsory education, the enforcement of the corporal punishment ban, which has been strengthened somewhat, learner retention, as I mentioned, regulating homeschooling, a slight extension to the random search provisions that will also be relevant to private schools. And then I want to make some general comments on the SGB policy making functions, talk a little bit about the history of cooperative governance in public schools, and then talk about the major changes in terms of schools' codes of conduct, and then the admission and language policies. And finally, I will briefly touch on the lessons to be learned from the Bella for private education. Next slide, please, Andrea. So as you can see, the timeline for the Bella Act is a long one. It started in 2017. There were many submissions received when it was introduced by the then Minister Angie Motshekga. It was then revised and only introduced post-COVID in 2021. And again, there were over 32,000 written submissions, and many of us also participated in the parliamentary processes, and there were national and provincial public hearings. The bill was then passed in the National Assembly in 2023. The bill then went to the National Council of Provinces, and again, that whole process started again, and there were new amendments to the SGB powers on language and admissions policies. On the eve of the legislation, on the eve of the elections, there was this, there was a rush to get through a whole lot of legislation by the ruling party, the African National Congress, one of which was the Bella Bill, but it wasn't signed until the 13th of December this year, 13th of September this year, excuse me. The president, in typical style, has also said that the school governance provisions are not yet in effect for the next 3 months. He wants to allow for further consultations. I think one of the things you can see here is that the consultations have already been extremely extensive, and they were hotly contested. And you would see that they were the major unions who supported things like this, the school governance amendments on the one hand, progressive civil society like equal education, Section 27, and these kinds of organizations also supported the amendments. On the other hand, organizations like the De Klerk Foundation, Solidariteit, as well as AfriForum are the ones that have threatened to challenge the bill and have said the bill is unconstitutional, the Now Act is unconstitutional, and ultimately undermine grassroots democracy and cooperative governance. As we go through those things, you can decide that for yourself. What I would like to say is that I haven't investigated this, but I am not sure how the legality of Cyril Ramaphosa's actions of introducing the suspensive condition is. My understanding is you can introduce suspensive conditions into legislation, but this would have to be directed by Parliament. And, you know, if you wanted to challenge this, I would see that this is something that could quite easily be investigated, or you could get a legal opinion on. Can I look at the next slide, please? So the first thing to note is that, as I said before, there has, for the duration of the current legal framework, been a debate about whether basic education is the same as the compulsory education phase, which up to now has been the 8-7 to 16 or grades 1 to 9, whichever comes first. In the recent case of Moko versus the acting principal of Malusi Secondary School, this issue was put to rest finally. Many people had said it has to be the compulsory phase. Other people said it has to be the acquisition of certain learning skills and so forth. So this case was one of the rare cases that made it directly all the way up to the Constitutional Court without going through the different tiers of the court system. What had happened was this boy, Moko, was excluded from writing his matric exam because he hadn't attended Saturday classes. And in what was a very strident judgment, the Constitutional Court said the basic education phase has to extend for the duration of the schooling phase for it to make sense for learners to go on to acquire, to access higher education and so forth. There's still some lack of clarity around TVET on that, but I would imagine that TVET would take a different route. The other very significant introduction in the Bella Act is the introduction of grade R as a compulsory schooling year. This is in line with international developments all over the world, and it's a very evidence-based development in that we know that in South Africa, at the end of grade 4, our learners, the majority of them are showing that they can barely read for meaning, and that if we introduced an extra year of schooling in addition to other things like improving our language of learning at the foundation phase, this could improve our learning outcomes at the end of the foundation phase. So this has been done. There is a lot of debate on whether people are convinced that it will be a smooth transition, although people welcome this introduction. At the same time, there's a lot of caution that this must be, the introduction must be accompanied by sufficient resourcing in terms of teachers and learning support materials, play-based learning programs, and so forth. A lot of the research from people like Bram Fleisch, etc., have shown that for many years, especially in historically disadvantaged schools, learners that go to preschool are just exposed to rote learning rather than doing all those things that we are taught as mothers to be aware of, like fine motor skills and gross motor skills and so forth. So let's wait and see what happens with ECD. Next slide, please. Then to enforce compulsory education, which as I've said, starts in grade R and ends in grade 9, and which is not the basic education phase. They have strengthened the criminal sanctions for parents who do not send their children to school during the compulsory phase. This has gone up from 6 months to 12 months, or they can get a fine or both. And similarly, a similar fine is imposed on those people who prevent learners from accessing schools. An example would be during service delivery protests. We know that roads have been burned, schools have been burnt. So some of the debates around this have been that where parents are not sending their children to school, you shouldn't be criminalizing this. This is not in the best interests of the child, because you'd be forcing the child into the state system. Also, we have to look at the evidence for why learners are not going to school. So if, for example, a 15-year-old learner, 15-year-old girls are dropping out of school in a particular area because there are many pregnancies and they are being discouraged from returning to school, we should have strategies in place there to make sure that girl learners who are getting pregnant are staying in school. So that's one of the criticisms as well. And then one of the other criticisms is that the Criminal Procedure Act and the normal penalty provisions not sufficient to deal with people that are preventing learners from going to school during service delivery protests, for example. Next slide, please. Then there is also the strengthening of the corporal punishment ban. Up to now, the ban has been in place since 1994. Private schools in the Christian education case also tried to get an exemption from the corporal punishment ban by saying that it's part of the way children are disciplined in terms of the religion of parents, and the constitutional court in that case held that the parents' rights had to be weighed against a range of rights of children, and that they refused to grant the exemption to those private schools. But there has never been a definition. The definition accords with international law definitions, and it addresses gaps that could, for example, be used where learners are corporally punished, and people argue that it doesn't fall within the definition. When one of my sons, I think was in grade 6 or 7, they went on a school camp, and one of the boys who was a little overweight was made by one of the camp facilitators to stand in what they call a motorbike position for an extended length of time. So some would argue that it didn't theoretically fall under the definition of a corporal punishment. It wasn't a caning or a slap. Something like this would now be clear that it is a form of torture that would fall within this definition. Using the same example, people may say that corporal punishment, if it doesn't happen in a class environment, is not corporal punishment. As in my previous job at Section 27, we saw a lot of learners being physically abused in hostels, particularly learners with special needs. So the definition has, or the scope of corporal punishment has been widened to include hostel accommodation as well as school activities. So with the camp example I just mentioned, the facilitator there would also be guilty of corporal punishment in terms of this definition. Again, there is the criminal imprisonment sanction and a fine. Over and above this, you will also know that there would be the SACE procedures, and in provincial education departments, the labor relations process as well. Next slide, please. As I mentioned, during COVID, there was a lot of talk that dropouts had increased significantly as parents kept their children at home, particularly where they were concerned that there were maybe elderly people at home that could get really sick, or the children themselves had certain diseases, chronic diseases, and so forth. Others have argued that there's been a lot of recovery on this dropout. Nevertheless, the Bella Act has sought to address this. It's made it compulsory for the headmaster or headmistress of a school to investigate where a learner is not at school for more than 3 days. Again, and then to come up with interventions to bring the learner back into the fold. Again, this has been criticized because there is a lot of research showing that the reasons why learners drop out are multi-pronged, and there are multiple reasons, and the solutions have to be multi-pronged. And I think there's a concern that this places a lot of responsibility on the school community and just abrogate and lets the rest of the school management or the different tiers of school governance escape responsibility for addressing dropouts in schools in the compulsory phase of education. This doesn't apply to grades 10 to 12. Next slide, please. Schooling. So here there has been the regulation of homeschooling. Previously, prior to COVID, all parents had to do was make sure that their learners were registered with the Department of Basic Education. Under the new Bella Act, this has been tightened up, and the minister can now approve an application subject to the best interests of the learner principle, and it requires that home education be age and grade appropriate and predominantly aligned with the CAPS curriculum. And parents must ensure that the necessary resourcing is provided, and at each stage of the learner's education, whether it's the foundational phase or the end of the compulsory phase, and so forth, that these learners are appropriately assessed. It doesn't apply to the periods between grades 10 to 12, but here, as in private schooling, it depends on the kind of exam a child intends to take, and obviously parents would then have the responsibility to register their child with whether it's whatever matric exam system they decide to take, whether it's A levels or IBE or whatever it is. So yeah, next slide, please. I should also say one more thing about that, which is that there has been a huge increase in homeschooling. The reasons for that appear to be largely that parents are unhappy with things like religion at school. They want more religion at school. They want less integration at school, and therefore are choosing to keep their children at home. In a private school context, I have also noted that after the COVID period, and where people had experienced a lot of financial problems, a lot of the boys, or some of the boys that I knew at my son's schools, for example, their parents had opted to homeschool them. So that's just by the by and may be of interest to those of you in the private education system. Then the random search provisions. I know at my boys' schools that random searches do occur. In the past, this has been only for dangerous objects and illegal drugs. This will now also include alcohol. So quite simple, and in the context of what we're seeing in some schools, I think also necessary. Next slide, please. So coming now to the policy-making functions of SGBs, they have a wide range of policy-making functions that was introduced in the Schools Act, admissions policy, language policy, schools code of conduct, including pregnancy policies, the religion policies of schools, and they will determine the amount of fees to be charged at public schools. The major changes that have happened, as you know, are to the admissions and language policies, but there have also been changes in respect of codes of conduct. And I think here private schools should take note. And then also some progressive changes to the fee exemption application requirements. Next slide, please. Andrea, next slide. No, go back. Sorry. Have I lost a slide somewhere there? Okay, I'll just speak to it from my own slide. So basically, to just give you some background, I was having a discussion with my son yesterday where he heard I was doing this, and he said, well, Mum, there's a real problem with the new Bella Act. The Bella Act takes away all the school governance, all the school governing bodies' functions. And the other thing that it does is that it now, I can't remember what was the other thing he said now, sorry. But basically, he had all these issues with the school governing body functions. And yes, the other thing he said was that anyway, it's a betrayal of what was agreed to in 1994 at CODESA. And what my slides will show is that the school governance model that was developed in 1996, or at the time of the transition in 1994, was something that parties agreed to, but parties agreed to under pressure. They had moved from a system of centralized control, a very authoritarian education system under apartheid, of which the two pillars were the unequal financing of education and a very authoritarian curriculum called Christian National Education. At the time of the transition, both sides, the liberation movement and the previous government, both wanted school governing bodies, but for very different reasons. The old government wanted to secure minority rights. They wanted to charge school fees, and that's how former Model C schools came about, and then also determine the policies at their schools. That is really the model that we have today. On the other hand, coming out of June 1976 and so forth, people wanted more grassroots involvement, in parental involvement in their children's education. What happened after the Schools Act was that there was all this school governance litigation, and I will talk to that. Like the Ermelo case, the Rivonia case, and so forth. And in those cases, there was a lot of contestation between the historically white schools and the provincial education departments. And a lot of those cases, especially those initial cases, the outcomes were very different before they got to the constitutional court level, some going in favor of the schools, some going in favor of the department. But underlying a lot of these issues it was about keeping white schools white and keeping Afrikaans schools Afrikaans. And that is where a lot of the conflict between provincial education departments and former white schools came into play. Can we look at the next slide, please? So I will talk to some of that litigation soon, but just to say first, to talk to the changes in terms of codes of conduct. The school's codes of conduct is regulated in terms of Section 8, and that is, there are also guidelines to guide schools' code of conduct in terms of what is correct, in terms of rules and due process, and so forth. A few years ago, there was a case called the Pillay case, or that we refer to as the Pillay case colloquially. And in that case, there was a girl who attended Durban Girls High, and her mother insisted that she be allowed to wear a nose ring as part of her Tamil religion and her Tamil culture. And they went through the court system, starting with the Equality Court, going up to the High Court, the Supreme Court of Appeal, and eventually the Constitutional Court, where they found that not allowing her to wear her nose ring was discriminatory. What the court said was that you have to reasonably accommodate people of different religions and different cultures, and they developed a test for that. And now this has also been formalized into the new Bella Act, where it is now required that every single school, a public school, has an exemption provision that makes allowances for cultural beliefs, religious observances, and the medical circumstances of learners at a school. So, for example, if a learner has to wear a bracelet to show an allergy and the school says absolutely no bracelets, there should be an exemption provision that says a learner can apply for an exemption to wear a bracelet, which is not adornment of any kind, but rather for medical purposes. And also they've codified some of the principles around due process, and disciplinary procedures must comply with the best interests of the child principal. Note that compliance with the best interests of the child principal is a recurrent theme of mine and a recurrent theme in the Bella Act coming out of the jurisprudence, and I will show how it's relevant in private education as well. Next slide, please. So this is a quick slide, brief slide. Parents, single parents, no longer have to do all the work when they apply for school fee exemptions, but they can just submit an affidavit to say they've got an uncooperative biological parent, other parent, because they, and therefore the school will have to look at only the single parent's salary and give exemptions on that basis. Next slide, please. Okay, I've spoken to that, and that's really just to show negotiated transition. There was a lot of contestation, school governance litigation, there was a lot of contestation. The Bella Act, there was now a lot of contestation, and I've mentioned the organizations there. Next slide, please. So the school governing body jurisprudence, I'm going through it quite quickly now to just say that, as I said, there were lower court cases for many years, and then the Ermelo case happened. So the Ermelo case has been the case that has established clear principles going forward, both in the legal frameworks and in the jurisprudence. Ermelo was about a single medium school that was refusing to become a dual medium school and take in English learners. It was only an Afrikaans school. The school had a lot of place, whereas schools in the surrounding areas were overcrowded, but they refused to change to a dual medium school. The SGB powers were then dissolved. The SGB was dissolved. The court, in all these cases that are listed here, found that the provincial education departments had not acted in terms of the Schools Act procedures and had acted unlawfully, but they nevertheless found in favor of the rights of the child, whether it was the right to equality or the best interests of the child principle, in terms of the broader principle of justice. The one thing that they've said, which is very important, is that the governing body of a public school must acknowledge that it acts not only in the interests of the community, but it also of the school community, but it is also entrusted with a public resource and must therefore look at the broader interests of the community. So, for example, as I said, as in Ermelo, if there are no places in surrounding schools, then you would have to look at the fact that Ermelo has space and should open up. This is very different to the Overval judgment that organizations like AfriForum and so forth rely on, that Panyaza Lesufi lost when he tried to take to the Constitutional Court. And the difference in that case, there were a couple of differences, but the main difference in that case was that the surrounding African schools all had places to accommodate the learners that were looking for places in the grade 7 year in that case. And then the principle of cooperative governance was reaffirmed in those cases, as well as the principle of grassroots democracy. And the court said, before running to court, you must know national makes policy and law, provincial runs the province, education in the province, and localized, you determine your policy. Coming now to the policies. If we can move on to the next slide, please. Tim, am I running out of time?
You okay?
Okay, how long do I have? 5 minutes, 3 minutes. One of the myths that exists about the Bella Act as it is now in operation is that SGBs must submit their admission and language policies or any amendments to these policies to the HOD for approval. This was the case prior to the last amendment. But even then, the HOD had to evaluate those policies and evaluate them according to the normative and rights-based criteria coming out of the jurisprudence of the cases I mentioned. And that is the needs of the broader community, the best interests of the child principle, equality, Section 9, are there other places available at other schools? Is there space available at this school? The efficient use of resources, and in terms of language policies, whether or not it's practicable, and so forth. But then, as it went to the NCOP, go on to the next slide, please. I'll skip this. They took away giving all those policy making or the ratification process from the HOD. And basically, SGBs can now make their own admission and language policies, but their admission and language policies must reflect this normative criteria, this rights-based criteria that I have spoken about. But the HOD can still direct a school to admit a learner, similar to what was decided in the Rivonia judgment. You will recall in the Rivonia judgment, they found that the MEC had acted unlawfully, but that the admission of one learner in that particular instance was something that the MEC could, or the head of education, I'm sorry, could still direct. At the same time, they can still also force a school like Ermelo to change their language policy, but there are very specific notice requirements and public participation consultations that will be required. And SGBs can still appeal all these directives. My view is that I think it deals with all of the cooperative governance issues, and that this normative criteria is a good way to make sure that HODs don't act unlawfully and to make sure that SGBs also don't act unlawfully. Progressives say that it's an important imperative to transform, whereas the DA and AfriForum, etc., say if this still is in place in January next year, they will challenge the act. Coming now to private schools. While there has been relatively little regulation of private schools up until now, the numbers of private schools have been increasing. We talk of the mushrooming of low-fee private schools. Next slide, please. And with that, there have been some judgments in key constitutional cases. I am not going to go into the Pridwen judgment or the Wesley judgment, but I will just talk about the principles, and there's a reason for that. The first is that in the Pridwen case, there was the question was whether in this particular case, where termination clause was enforced by the school, was there or had the due process requirements been fulfilled in that the learners had not been given a chance to have their say. And what was decided in that case, both in terms of Section 28(2), and if you can move on to the next slide, please, and in terms of Section 29, was that due process must be inferred from both Section 28(2) and Section 29(1). So whenever you decide to suspend or to expel a learner, there must be the learner has a right to have a voice as well. The other big principle that was established in terms of these cases, both mentioned in Pridwen and in the John Wesley case, was that whatever happens at a private school, the standards that they adopt must not be inferior to that of comparable public schools. So the example that I've mentioned to public schools, to private schools, is that some of you may have codes of conduct that allow you to suspend a learner for a month, whereas in terms of public schools, you can only suspend a learner for up to a week before their learning and teaching is disturbed and their right to basic education is violated. So move on to the next slide, please. The last thing I want to draw your attention to is, and this is very important for you, it's international law has developed something called the Abidjan Principles, which is bringing together all the international instruments of which we are party to and have ratified many of them. And they also talk about the necessity for states to regulate private schooling and to have things like due process requirements, prohibit corporal punishment, and so forth. So my message to you on that last slide, and sorry I rushed this at the end, is that I would suggest that given the strong voice of children and the necessity for the strong voice of children to be heard in terms of Section 28 in the school governance jurisprudence, the private education jurisprudence, and much, much more widely, I think it would be important for you, where possible, to revise your policies and your codes to ensure that they are constitutionally compliant and litigation proof. I also think that to the extent, like I said, I don't get a sense that this is imminent, but to the extent that there would be further regulation extending to private schools, you should probably then organize yourselves to contest the public participation process. Thank you very much.
Thank you, Farinaz. I've been asked to just make a few comments around corporal punishment, and you saw the definitions that Farinaz put on her slide, and it's very broad. So there are 3 specific sections, and then there is the final coverall, which says any acts which seek to belittle, humiliate, threaten, induce fear, or ridicule the dignity and person of a learner is outlawed. So any kind of physical attack on a student, including throwing objects at the student, and that takes me back to school where my teachers used to throw blackboard dusters. Not sure if blackboard dusters even exist anymore. The other thing that I noted in terms of the third section is that you can't force a child to do exercises which are not in accordance with the curriculum applicable to the learner. Now, that's not clear whether that is physical exercises like push-ups, because I'm sure that still happens in schools, but that might also include writing lines or essays on the noise grass makes when it grows or the inside of a ping pong ball. I suspect that those will also be outlawed in terms of that section, but those interpretations will come as these matters come before the courts. So corporal punishment is not necessarily limited to the act specified in the legislation, but the general rule is that it includes any deliberate act that inflicts pain or physical discomfort, however light, to punish or contain the child. So the definition is broad, which is appropriate in ensuring that children are not punished inappropriately and that practices that many of us endured at school are outlawed. But obviously with the broad definition, there are some grey areas which might raise concerns for teachers and for schools, particularly because the legal consequences of corporal punishment, inflicting corporal punishment at a school, is that the person is guilty of an offence and liable on conviction to a fine or imprisonment or both. And what that fine or period of imprisonment is will be in the discretion of the court. So the court will decide. It's kind of they'll know it when they see it and they'll punish it accordingly. So what constitutes or might constitute corporal punishment includes both physical and psychological activities. So I suggest the focus should then be on positive discipline, which rejects entirely the use of either physical or psychological violence as a teaching tool. It focuses instead on guiding children's behavior rather than enforcing good behavior through fear, with the teacher and the school eliminating fear in the classroom. I know a lot of this is easier said than done. Whilst no doubt there should be no corporal punishment, the definition of that conduct is very broad, and the interpretation of the specific wording by the courts will provide essential guidance as we go. I suspect that the legal maxim de minimis non curat lex is a phrase that might become as well known in education circles as dolus eventualis became during the Oscar Pistorius trial. What that means, de minimis, means that the law is not concerned with trivialities or with trifles. The point being that the courts, in exercising discretion in matters of corporal punishment, will face difficult cases that are on the cusp between what is corporal punishment in the full meaning of the definition and what should be the subject of criminal sanction. So an important point to make is that there's the prohibition of corporal punishment runs across both private and public schools. And then finally, I just want to talk briefly before handing over to Dr. Nadeem Mohammed, who will talk to this a bit more. But teachers have the same remedies against students in the occasion that a teacher is threatened or abused by a student that they would have against unlawful conduct by any other person. That includes orders under the Protection of Harassment Act, charges of assault, interdicts. These are remedies that operate in the courts, and they must be approached with some caution as they tend to be nuclear options. They are absolutely appropriate where the circumstances are warranted, but the consequences of the use of those remedies could affect the teacher's relationships with the rest of the students in their class or the rest of the students in the school or the school. They could inflame a situation that should rather be calmed. They could affect the school body and the parent body broadly, and ultimately they may affect the reputation of the school. Again, there are circumstances where they are absolutely appropriate, but it is wise to think through the whole matter before approaching the police or the courts so that you have identified and are ready to deal with the consequences. Our next speaker is my fellow director, Dr. Nadeem Mohammed, who is the driving force between our employment law department, responsible principally for knowledge content in that department, but Nadeem is responsible for much more than that. He'll be talking about the prevalence of violence, harassment, and bullying, its effect on school leaders and teachers, on the harassment code and its application in schools, and following from what I've just spoken about very briefly, the trust relationship between teachers elect to take legal action against learners or the school. Nadeem.
Thanks, Tim. Thank you for that very kind introduction. Yeah, so I think let me start with setting some context around violence and harassment and bullying in schools, specifically from the perspective of violence or harassment that's actually perpetrated or inflicted by learners towards educators and teachers. The presence of harassment and various forms of violence in schools is always concerning. And the prevalence of harassment, bullying, and violence seems to be increasing, including instances of bad behavior perpetrated by learners. The issue of harassment, violence, and bullying in schools remains a persistent concern, with recent trends suggesting an alarming increase in prevalence. Media reports highlight the growing impact of learners' disruptive behavior on teachers, compromising their safety as well as the general safety at school, mental health of staff at a school, and ability for teachers and educators and other staff to perform their duties effectively. In some cases, teachers or educators have been compelled to report criminal conduct to law enforcement and pursue legal action against their employers for damages. And I'm going to come to that component shortly in relation to how that may possibly implicate or affect the trust relationship, the employment relationship, and the trust relationship that's a core component of the employment relationship. A 2019 study, not too long ago, about 4 years ago, focusing on a cluster of Johannesburg schools, revealed a troubling rise in learner and teacher violence, coupled with significant underreporting of such incidents. Verbal attacks and harassment were identified as the most frequent forms of abuse, which negatively affected teachers' well-being. Now, while public schools often dominate these reports and studies, it is crucial to note that private educational institutions are not immune from these issues. And regardless of the school setting, failure to address and eliminate these threats can lead equally to dire consequences for the private school sector, underscoring the urgent need for effective interventions across all educational environments. And so one of the key pieces of legislation that applies to schools from an employment law perspective is actually the Harassment Code. Now, this code comes under the Employment Equity Act, which explicitly prohibits harassment and categorizes it as a form of unfair discrimination. The Code of Good Practice on the Prevention and Elimination of Harassment in the Workplace, which was published in 2022, serves as a cornerstone document defining harassment and outlining employers' responsibilities in eliminating and combating it. So according to the Harassment Code, harassment encompasses unwanted conduct that impairs a person's dignity, creates a hostile work environment, or induces submission through actual or threatened adverse consequences. Now, obviously, there can be harassment of students or learners by educators or by peers. But what I'm focusing more on here is really the forms of harassment that manifest in relation to or affect teachers or learners or educators negatively. What harassment relates to specifically under the Employment Equity Act are the listed grounds. So if harassment takes place on the basis of race, gender, sexual orientation, disability, and age, and one can see within a particularly school context, but even a wider workplace context, how some of the verbal harassment or sometimes physical altercations can employ some of these prejudices when they do manifest. In an educational context, when a learner's behavior towards a teacher or staff member is intended to inflict harm, whether verbal, physical, psychological, or through cyber platforms, and creates an unsafe or hostile working environment, the school in its position as the employer is legally obligated to take immediate action to eliminate the harassment and implement appropriate disciplinary measures. And in this regard, schools are strongly encouraged to implement the relevant policies such as a harassment policy and disciplinary processes and so on. Finally, what I'm going to deal with, and I'll try to do this quite quickly because it's somewhat complex in a way, is what is the impact on the trust relationship in the employment context when a teacher elects to take legal action where abuse, violence, or harassment is perpetrated by a learner. And I think there's three important things to consider here. The first is the role of teachers in education when an educational context extends beyond instruction to include the safeguarding of learners. As indicated earlier, disturbing trends have emerged where teachers themselves have become victims of assault by students. And while legal recourse for effective teachers is possible and well established, as Tim indicated earlier, this raises an important and complex question. Could pursuing damages or legal action against the school or the learner by a teacher potentially erode the fundamental trust between educators and the institutions? Now, the first thing to remember here is that the employment relationship is fundamentally built on trust, and actions that undermine this trust may provide grounds for termination of employment. Nonetheless, I think what we know for sure in terms of legal precedent is that a mere breakdown in trust alone is insufficient to justify unilateral termination of employment. Rather, an irretrievable breach of trust becomes relevant when considering appropriate remedies, which typically include either specific performance or damages or compensation of some kind. Now, the impact of a teacher's legal action on the trust relationship with the school requires a case-by-case evaluation. Scenarios may vary widely. For example, you could have a teacher seeking damages while wishing to continue their employment, to those instances where due to an assault or other very extreme factors, the teacher no longer desires to remain at the institution. Now, it's crucial to note that a teacher's exercise of their right to pursue legal action cannot, in isolation, justify a unilateral termination of employment by the school. Such a dismissal could potentially be deemed both procedurally and substantively unfair. Lastly, what I'll say is that it's important to note that the principle of procedural fairness extends beyond teacher-school relationships. The Constitutional Court's ruling in the Pridwen case specifically indicates that private schools here cannot unilaterally terminate contracts with learners' parents or guardians without adhering to fair procedures. And this typically includes providing opportunities for affected parties to present their case. I think that's, I'll end there, Tim, in the interest of time.
Thanks, Nadeem. I know we're running out of time, but I'm going to ask Tata Marapula, who's an associate in our employment law department, to talk to us about some of the cases where teachers have taken legal action against schools as a result of learners' behavior. So over to Tatu. Thank you.
Thank you, Tim, and good afternoon to the colleagues on the call. Thank you very much for joining us. I see that I'm almost out of time, so I'll be quite brief. Following from what Nadeem has said, there's been two recent judgments from the High Court sitting in Mpumalanga, as well as the Western Cape, where the courts in principle confirmed that if a teacher is assaulted by a learner, that particular teacher can then bring a damages claim against either the relevant school or the department. And in particular, the matter in the Western Cape High Court, the Western Cape High Court found that a school has a legal duty to take reasonable steps to ensure that the teacher, or a teacher rather, is not harmed by learners at the school environment. So the net effect of these judgments, so brief, is that there's a legal obligation on schools to ensure that the school environment is safe for school staff such as teachers, as well as other staff on the premises. And in the event that a teacher is assaulted, that particular teacher can then actually bring a damages claim against either the school or the department. Thank you, Tim.
Thank you. So with my thanks to Dr. Faranaz Beriava, to Dr. Nadeem Mohammed, and to Mr. Tata Marapula, and to all of you for attending this webinar, that brings an end to our presentation for today.